constitution whether the charge is effective on the basis of complete particulars. When counsel submitted that the particulars of the charge sheet as framed did not disclose the issues it needs to, and as such it was defective. He submitted that the particulars of the charge sheet wanted to bring out the following: the criminal intent, whether there was use of weapon or not, the part of body that was assaulted, and whether the alleged assault was the result of a just cause. Section 137 of the CPC provides the rules for framing of charges and information as follows. What? The following provision shall apply to all charges and information, and notwithstanding any rule of law or practice, a charge or information subject to this court not be open to objection in respect of in its form or content if it is framed in accordance with this court. A mode in which offences are charged, account of a charge or information shall commence with a statement of the offence charged called the statement of offence, and 2, the statement of offence shall describe the offence shortly in ordinary language, avoiding as far as possible the use of technical terms and without necessarily stating all the essential elements of the offence. And if the offence charge is one created by enactment, shall contain a reference to the section of the enactment creating the offence. End of quote. It would appear to me that what counsel decides is that the issues of evidence be disclosed on the charge sheet. Those are issues to be proved during the trial and therefore not necessary to be included in the charge sheet. The provisions of section 137 CPC quoted are very clear. In any case, it is not lost on me that it has long been held that courts should not pay undue regard to technicalities, even substantive justice is to be undermined. Moreover, section 214 of the CPC is very elaborative on the manner of amendment and substitution of charges. The court may order that a charge be altered at any time before close of the prosecution's case if it is of belief that the charge is defective in form or substance. It therefore follows from the aforestated reasons that nothing turns on this ground, and I find the application by the defense at this stage is not merited. It is dismissed, and the accused person is thereby invited to enter plea without any further delays. The court finds as follows: that at the risk of being direct, let me say from the onset that not much turns on this ground. The law relating to contempt of court orders, which was previously set out in numerous acts, is now consolidated and contained in the Contempt of Court Act of 2016. Criminal contempt of court is conduct that undermines the dignity of the court, interferes with proper running of court proceedings, or obstructs the administration of justice. This court, being our subordinate court, has jurisdiction to punish for contempt on the face of the court. That is, where a person has willfully disobeyed an order or direction of a subordinate court, such as this one. It is therefore the offense of being disobedient or discourteous towards the court and their officers in the form of behavior that opposes or defies the authority, justice, and dignity of the court. Contempt manifests itself in the willful and intentional disregard of or disrespect for the authority of the court, a behavior that is regarded illegal because it does not obey or respect the authority of the court and their processes and tends to lower the dignity of the court. As was held in Constitutional Petition number 87 of 2017, the Constitution in Article 4, Article 3, declares Kenya as a democratic state founded on national values and principles of government, which include the rule of law and democracy. Disobedience and disregard of the authority of the court violates national values and the Constitution. In that regard, courts punish for contempt in order to maintain their dignity, authority, the rule of law, democracy, and administration of justice as foundational values in our Constitution. It is therefore a fundamental rule of law that courts orders be obeyed, and where an individual is enjoined by an order of the court or to do or to refrain from doing a particular act, we have
We apologize. We are fine. It has taken the labor of 3 men to put off the phone. It's a very complicated phone. Sorry.
Thank you. Okay, I'll page at paragraph 21. It is therefore fundamentally reviewed that court orders be obeyed, and when individuals enjoined by an order of the court to do or to refrain from doing a particular act, they are duty to carry out that order. The truth of this notwithstanding, I'm alive to the fact that the alleged contempt is not against this file, but rather in misdemeanors application 106 of 2020, which was handled by my brother who wrote your note. In addition, counsel for accused did not demonstrate that there was a form or there is a formal application for the said contempt, which is 6 to pursue. And positive I mean, I would appreciate that the fact that it would be a mockery and improper for me to propose to rule on the said content when the same was not for me. But in a file on proceedings still pending before a court of concurrent jurisdiction. It follows, therefore, the allegations of content cannot be spot on directing, but the accused person enters plea unless and until there is a formal application and or an order from the High Court in this regard. On the second issue on whether the indication of Christian names, tried, can release and sentence undermines the Constitution and makes the charge sheet illegal or defective, I find as follows: that Section 137D of the CPC outlines how persons shall be described in a charge sheet, and it does so in the following terms. Description of persons provided that the description or designation in a charge sheet or information of the accused person or of another person to whom reference is made therein shall be reasonably sufficient to identify him without necessarily stating his correct name or support, style, degree, or occupation, and if owing to the name of the person not being known for any other reason, it is impracticable to give such a description or designation. A description or designation shall be given as is reasonably practicable in the circumstances, or the person may have arraigned in court on the 15th of January to answer to the same judges, but he was defied separately as a result of numerous applications made before court. Giving rise to this ruling was an application made by Dr. Amino. The learned doctor submitted that the police were in contempt for failure to release the accused person, even when the court had directed that they do so. It was this contention that this contempt was yet to be cured, and that the police of the prosecution remain in contempt, and that the proceedings hearing, in particular, he cannot proceed referring to the charge sheet. Learned counsel submitted that the same undermines the Constitution, the column headed as Christian name was in breach of the constitutional provisions that we have no state religion in Kenya. We contended that such a column gave misleading information. Referring to the nationality or tribe, learned counsel submitted that our Constitution uses the word community and avoided the use of the word tribe. We contended that we should not emphasize the tribe at all on a state document of the tribe. At the far bottom of the charge sheet, counsel raised issue with the provision for sentence, and he submitted that the provision on the line of this provision on the charge sheet undermines the presumption of innocence of an accused person. Moreover, counsel submitted that in accordance with Article 157 of the Constitution, it is a mandate of the DPP to institute proceedings against an accused person, and counsel contended that the fact that the charge sheet was leveled the Kenya police and that it was stamped by the police as well as the DPP only went to show that the DPP had no input in the preparing of the charges against the accused person. He asked the court not to rely on such a document. Counsel went on to submit that the charge sheet as framed was defective and submitted that the particulars of the charge sheet ought to bring out the following: 1, the criminal intent; 2, counsel submitted that it was not disclosed in the particulars of the charge sheet whether there was a use of a weapon and whether what part of the body was assaulted, and whether the alleged assault was as a result of a just cause or self-defense. Counsel submitted that the accused person needed to be provided with all this so that he could prepare his defense properly. Mr. Mosi for the state submitted that the issues raised by Dr. Kamima on content had already been dealt with or addressed with in a lump previously by the court. She submitted that the court had ruled that the accused person takes Plead, and seeing nothing new had come up, it was only right that the accused person proceed to take Plead. She led the court to be swayed into reviewing the ruling and contended that the accused person is at liberty to move to the High Court and have the issues addressed rather than seeking to upset the ruling of the court. On the issue of the charge sheet, Ms. Nyamosi was emphatic that the prosecution has discharged his burden in law, and that the law provides that the charge sheet needs to have sufficient information and particulars to enable an accused person to respond to the issues raised. Counsel drew the court's attention to the case of Julius Kamau versus Republic, where the issue of unlawful detention was dealt with by the court, and she proceeded to emphasize that any issues of constitutional breach and the remedies thereof can and should be addressed by the Constitutional Court. She contended that she finds nothing stopping the accused person from taking Plead, as there exists no appeal or stay of such limitation, and that no prejudice would be suffered by the accused person if he wants to take Plead. I considered and analyzed the submissions by both parties and find as follows. I found that the issues for the determination are as follows. 1. Does the contempt stop the accused person from taking the alleged contempt stop the accused person from taking? And 2. Whether the presence of Christian names, tribes, Kenya today's sentence make the charge sheet illegal. And 3. Whether the charge sheet is defective on the basis